The respondent, however, countered this leadership structure on the grounds that the said leadership structure cannot be taken into account as the said leadership structure came into existence without following the due process of election appointment as provided in the NCP constitution. In this regard, the respondent made the following submissions, which is again matter of record. Even though the preliminary submissions of the respondent on the leadership structure is that no leadership structure exists which can be a basis for rendering any finding on the preliminary issue, the respondents in the alternative relied on the resolution dated 30th June 2023, whereby Shri Ajit Pawar was elected as the president of the NCP. Relying on the resolution, the respondent submitted that the constituent members of the leadership structure were changed by electing Shri Ajit Pawar as the president of the party, and if any leadership structure must be considered, then it must be in which Shri Ajit Pawar is the president. The petitioner disputed the aforesaid claim by submitting that the alleged event of 30th June 2022 as claimed by the respondent are inherently improbable and the election of Shri Ajit Pawar was not in accordance with the procedure prescribed by the NCP constitutions. Findings and conclusion. At the very outset, I wish to make certain observations. Even though both the parties have submitted, probably owing to the tenor of the observations of the Honorable Supreme Court, that preliminary issue has to be decided on a prima facie assessment of material on record. In fact, both the parties have, contrary to their own submissions, led extensive evidence to buttress their respective arguments with facts in respect of the relevant leadership structure. Be that as it may, I am not inclined to diverge from the Honorable Supreme Court's directives to consider evidence of both parties in respect of validity and or illegality of organizational stroke leadership structure, in which it was this position of prima facie assessment that I adopted in my final order dated 10 January 2023 when I proceeded to decide the disqualification petition number 1 to 16 of 2022, the Shiv Sena disqualification matter, where I have already held that jurisdiction under the 10th schedule only mandates a prima facie adjudication as to what leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not leadership structure was pursuant to a validly held election. It is a matter of fact that till 29 June 2023, there has been no contemporaneous challenge to the leadership of Shri Sharad Pawar as the party president. However, the said position was sought to be altered by the Ajit Pawar faction by way of the resolution dated 30th June 2023. Thus, prima facie, as on 30th June 2023, there existed two parallel claims in respect of the NCP leadership, the one according to the petitioner claiming Shri Sharad Pawar is the party president, and the other one claimed by the respondents where Shri Ajit Pawar is the party president. In order to try and demonstrate that their separate claims to the leadership of the party by their respective presidents, both the parties have led oral and documentary evidence and argued exhaustively. Both the parties claim that it is their leader who was validly elected according to the NCP constitution, and the claim of the other side therefore cannot be entertained. Furthermore, both parties claim that other side's claim as to the leader's election as the party president was not accordance with the NCP constitution. As noted earlier, under the 10th schedule, while deciding the preliminary issue, I cannot go into the validity and or legality of elections to the leadership. I am therefore confronted with the rival assertions which clearly indicate the existence of two persons claiming leadership of the party. It is to be noted at this juncture that the respondent number 1 to 9 of petition number 1 of 2023 joined the government on 2nd July 2023. The resolution electing Shri Ajit Pawar came to be passed on 30th June 2023. This leads to a peculiar situation where there are seen to exist two parallel leadership structures and two party presidents prior to the alleged conduct attracting disqualification. Undoubtedly, the rival parties have tried to lead evidence to justify their opposing stand about the validity of the election of their leader to the post of president. They have tried to show how their separate processes of election were justified by the NCP constitution. I am not inclined to go into their evidence or appreciate their evidence-based arguments because this would lead deciding whether the rival elections were in keeping with the constitution and the rules, and whether factually Shri Sharad Pawar or Shri Ajit Pawar were validly elected, or whether in fact Shri Sharad Pawar had resigned at the relevant time. I possess no jurisdiction to issue any such declaratory orders. In the absence of such jurisdiction, which is certainly not available under the 10th schedule of the Constitution, or the wherewithal to examine the correctness, validity and legality of parallel claims of valid stroke legal elections, I need not and cannot undertake such an inquiry. Thus, for this reason alone, relying on the test of organizational stroke leadership structure to examine the two parallel rival claims in respect of the leadership about the post of party president, I cannot arrive at even a prima facie decision on the preliminary issue. Irrespective of my findings herein above, if the leadership structure relied on by the petitioner is looked at even for ascertaining the prima facie position, it is seen that it cannot form the basis for determining the preliminary issue for the following reasons. The petitioner's reliance on majority in NCP working committee cannot be taken into account for determining the preliminary issue, as the composition of the NCP working committee relied by the petitioner is not in conformity with the NCP constitution. Article 21 of the NCP constitution, read with NCP rules, provides that the highest executive authority of the NCP is NCP working committee, which consists of 1. The president of the party, 2. Leader of the party in parliament, and 3. 23 other members, of whom 12 members are elected by the national committee and rest are appointed by the president. A perusal of the documents relied on by the petitioner to show the composition of the NCP working committee indicates that the NCP working committee had 28 members, whereas the NCP constitution provides for only maximum 25 members. The said document shows 16 permanent invitees, whereas the NCP constitution does not provide for any permanent invitees. The petitioner submitted that in the national committee, Sharad Pawar faction enjoyed the majority support amongst the delegates elected from the state committees. However, the petitioner has not provided any document which reflects the election of such delegates. Thus, in the absence of any record reflecting the election result and names of delegates, the said claim cannot be accepted by blindly appreciating it to be true. Thus, the submission of the petitioner that Sharad Pawar faction enjoyed majority support in the national committee cannot be relied upon to determine organizational majority. Support of the president and or will of the president is not a reliable factor to determine the preliminary issue, as both the factions challenges their respective leaders, claiming that the leader was not validly elected. As held earlier, under the 10th schedule, such claims cannot be adjudicated. It was open for both the parties to have initiated appropriate proceedings to get a declaration to that effect. In the absence of such proceedings or any findings thereon by a competent authority, both the factions cannot equally claim that the rival faction's leader was validly and or not validly elected. Thus, for reasons recorded herein above, I hold that leadership structure relied on by the petitioner and or respondents cannot be taken into account for determining the preliminary issue, as it would be an impossible attempt. Legislative maturity considered. As recorded earlier, the Honorable Supreme Court in Subhash Desai Supra has held that the question of who the real political party is has to be considered and determined after giving due weightage to 1. the NCP constitution, 2. the leadership structure of the party, and 3. legislative majority if two or factions claiming to be the real political party. Having arrived at the conclusion that leadership structure and or organizational structure does not provide a reasonable outcome to settle the issue of which faction is the real political party, I now turn to the test or mechanism that exists based on the legislative majority. Before delving further, the petitioner's submission that legislative majority cannot at all be taken into consideration has to be considered. The petitioner has placed reliance on paragraph 102 to 111 of Subhash Desai Supra in support of this submission. However, a careful reading of Subhash Desai Supra shows that the said submission is misplaced. Paragraph 102 to 111 of Subhash Desai Supra deals with the issue of who appoints the leader and the whip of the party in house. In the said regard, it was held by the Honorable Supreme Court that it is not the legislature party but the political party which appoints the whip and the leader in the house. The ratio cannot be read to mean that the legislative majority cannot at all be considered while determining the preliminary issue. In paragraph 168 of the Subhash Desai Supra, the Honorable Supreme Court has in clear terms laid down that for the purpose of disqualification petitions, the Speaker, while deciding the issue of real political party, has to take into consideration the leadership structure specified and identifiable from the constitution of the party along with the legislative assembly majority. The only rider provided is in the said paragraph 168 was that determination of who the real political party is must not be based on a blind appreciation of legislative majority. This is only a rider provided so as to make it clear that even the leadership structure outside the legislative assembly is also a relevant factor in the determination of who the real political party is. It also indicates the legislative majority. It also indicates that legislative majority is also a factor that is not prohibited from consideration. Thus, the submissions of the petitioner that legislative majority cannot be taken as a factor in arriving at a decision on the preliminary issue is not correct and hence rejected. Needless to mention that it is well settled by Supreme Court that where the question arises as to which group is the party, strength of each group becomes an important and relevant factor. It is thus obvious why the legislative majority becomes relevant creation to be taken into account to decide which faction is the real political party. In the present matter, the legislative majority is undisputed. The respondents claim that Ajit Pawar faction had the support of 41 out of 53 MLAs is not disputed by the petitioners. Even otherwise, the resolution dated 30th June 2022 passed by the Ajit Pawar faction shows that prior to joining the government, Ajit Pawar faction outnumbered the Sharad Pawar faction. It is also imperative to note that the very fact that the Sharad Pawar faction has filed disqualification petitions against 41 MLAs of the Ajit Pawar faction itself indicates the numerical strength of each faction. Further, the respondents' assertion that they have majority in the Legislative Assembly of Maharashtra, Legislative Council of Maharashtra and Legislative Assembly of Nagaland has not been disputed by the petitioners. It is made clear at this juncture that affidavits annexed by the respondents to the affidavit in lieu of examination in chief of Sri Anil Bhaidas Patil RW2 was not taken on record and thus not relied upon for my finding that prima facie Ajit Pawar faction had the legislative support. The respondents' assertion that even the vote share secured by the legislators supporting the Ajit Pawar faction is sustainably large than the legislators supporting the Sharad Pawar faction is also not disputed by the petitioners. It is to be also noted that the petitioner has not claimed legislative majority in the manner and has not even attempted to demonstrate it. Thus, in view of the above, I hold that preliminary issue as to which faction is the real political party is discernible from the legislative majority which existed when the rival factions emerged. Further, I hold that the Ajit Pawar faction had an overwhelming legislative majority when the rival factions emerged. Final conclusions on the preliminary issue. Thus, in view of my findings that the party constitution and leadership structure, organizational structure does not provide any reliable outcome to the question which faction is the real NCP political party, and consequently these cannot be yardsticks to determine which faction is the real political party, and to the legislative majority provides a clear and reliable answer to the question of which faction is the real NCP political party, I hold that the Ajit Pawar faction is the real NCP political party for the purposes of these disqualification petitions. Issue number 2. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule for the of the Constitution on account of their acts, omissions and or conduct? Now, with regards to this second issue, it's common again to the extent of the contents to group 1 and group 2. However, considering the importance of this issue, I may read it out in the second order as well, second group as well, even at the cost of repetition. The petitioner has concluded, the petitioner has contended that the respondents are liable to be disqualified on the following grounds. The respondents have gone against the official position of the NCP political party and joined hands with Eknath Shinde BJP government in Maharashtra on 2nd July 2023. The respondents have taken oath as ministers in the Eknath Shinde BJP government in Maharashtra on 2nd July 2023. Unilaterally and without authority, the respondents declared Shri Ajit Pawar as the president of the NCP on 30th June 2023. Unilaterally and without authority, the respondents declared Shri Ajit Pawar as the leader of the legislature party in the Maharashtra State Legislative Assembly on 30th June 2023. The respondents attempted to continue a chief whip who had been removed as a member of the NCP for indulging in anti-party activities. The respondents attempted to create confusion by opening party office without authority. Without any authority, the respondents called an open national convention on 5th July 2023 to ratify the illegal decisions on 30th June 2023. The respondents tendered affidavits in support of Shri Ajit Pawar's anti-party activities. The principal ground on which the disqualification is sought is that by joining the government on 2nd June 2023, the respondent number 1 to 9 is in disqualification petition number 1 of 2023, and by supporting the said action of respondent number 1 of to 9, the other respondents in disqualification petition number 3 and 4 of 2023 have gone against the will of the NCP political party and thereby incurred disqualification under paragraph 2(1)(a) of the 10th schedule of the Constitution. All other grounds are allied grounds arising out of the said principal grounds. In view of my finding that the Ajit Pawar faction was the real political party when the rival factions emerged within the NCP, respondents cannot be held to be disqualified on any of these grounds, as the decision of Ajit Pawar faction constituted the will of NCP political party. Consequently, the disqualification petition number 1, 3 and 4 of 2023 are liable to be dismissed. In view of my findings that Ajit Pawar faction was the real NCP political party when the rival factions emerged, the respondents cannot be held to be disqualified for grounds recorded in paragraph 76A and B. Even otherwise, irrespective of my conclusions about which faction was the real political party, for the reasons recorded herein below, the respondents cannot be held to be disqualified on the grounds recorded in paragraph 76. Irrespective of my conclusions on the real political party, in my considered opinion, none of the averments, contentions or pleadings raised by the petitioner, especially grounds C to H recorded in paragraph 76 herein above, fall within the ambit of paragraph 2(1)(a) of the 10th schedule of the Constitution. It is necessary to understand the scope and object of the said provisions of the 10th schedule of the Constitution. The object underlying the said provision was to curb the evil of political defection motivated by various considerations which endanger the foundations of our democracy. What is to be noted is that 10th schedule is intended only for the purpose of prohibiting and punishing defections, and that too with the objective of preserving the foundations of democracy. I am pained to observe that in the present matter, when the facts, circumstances and evidence are viewed, the misuse of the provisions of 10th schedule by political parties becomes apparent. It appears that the initiation of the proceedings is not to prevent maverick and irresponsible defection or to call an errant member to book. It is to suppress dissent within the party and open a new direction in the political tussle for power. The attempt is to stretch the provisions of 10th schedule to suit private objectives of individuals or parties rather than prevent the harm that is caused to elective democracy itself. In the facts and circumstances brought before me, it is necessary to consider the cardinal question: does every act of a member of the legislature that may be described as defiance or dissent or behavior of group of members of the legislative party in the House that goes against some other group within their own party falls within the meaning of the term defection under paragraph 2 of the 10th schedule. As the Speaker and even as an elected representative, I witness the daily churning of politics as it plays out before me. I see members, their political leaders and their parties as if through a kaleidoscope, making and breaking into new forms, forging new alliances, undoing old relationships, striking out in unknown directions. This is in the very nature of politics, and as we see it unfolding before our eyes, it is the reality of politics today. Surely every such action cannot qualify as defection within the meaning of the 10th schedule. The constitutional bench in the case of Kyoto Holohan versus Zuchilu and others has somewhat touched upon these aspects. I have referred to Kyoto and how Kyoto has dealt with these issues. Then, would every act of defiance or dissent or behavior of groups of members that goes against some other group within their political party fall within the meaning of the term defection under paragraph 2 of the 10th schedule? The question, no doubt, is foundational, but by no means is it the only question that arises for consideration. The companion question that arises is equally fundamental. Is the 10th schedule a tool to control opposition within the political rank of the party? Assuming that rightly or wrongly the behavior of the acts of the respondent in these groups of petitions of raising their voice against Shri Sharad Pawar and disobeying the diktats of Shri Sharad Pawar amounts to indiscipline, could such action amount to members having voluntarily giving up membership of the party, thereby attracting disqualification under the 10th schedule? The event that unfolded between 30th June 2022 and 2nd July 2022 were clearly in the nature of intra-party dissent within the Nationalist Congress party, and the members of the party stood divided between two leaders, i.e. Shri Sharad Pawar and Shri Ajit Pawar. But this conflict was clearly within the political party. Questioning the decision of Shri Sharad Pawar and going against his wishes cannot be said to be an act of defection or of leaving the party. It is a dissent expressed by the members of the NCP. At no point of time did any of the leaders, including the respondents, ever made any attempt that would amount to a statement or contention to leave the NCP political party. Members of the party expressing concerns against certain political behavior of other members of the party would not constitute defection. Under the 10th schedule, such collective dissent would remain to be a dissent within the political party, even when it began to be raised publicly on the platform other than party forums. It may not be to the liking of this leader or that, but it would still remain to be a dissent and not desertion. A word about dissent. Intra-party dissent by individual members of a political party need to be distinguished from collective dissent of a group in the legislative party. It further needs to be established that if such collective dissent has occurred, it amounts to defection from the party. Here, an examination of the motive also becomes relevant. I need to decide whether collective dissent against the party leadership can be termed as honest dissent within the political party, permissible in a democratic institution such as the political party. Further, whatever be the nature of the dissent, can it be given the status and character of dissent within the legislative party, which alone is a dissent on which the Speaker is empowered to act under the 10th schedule. A useful reference may be made to the recent judgment of the Honorable Supreme Court in the case of Balchandra L. Jarkiholi and others versus B.S. Yediyurappa and others, reported in 2011 7 SCC 1. It is an interesting case which had come up before the Honorable Supreme Court from state of Karnataka and touches upon this aspect. The fact of the said case were 13 MLAs of BJP and 2 other independent MLAs wrote to the Honorable Governor indicating that as MLAs of BJP they had become disillusioned with the functioning of the government headed by Chief Minister and also the leader of the legislature party who belonged to their own party. After stating their reasons, they added that they were withdrawing support to the BJP government headed by Mr. B.S. Yediyurappa, but they would support BJP government with any other leader from BJP in its place. On the basis of the said letters, Governor asked the BJP Chief Minister to seek vote of confidence in the Legislative Assembly and also intimated this to the Speaker. On the same day itself, the Chief Minister filed disqualification petitions against his own MLAs, accusing them of voluntarily giving up membership of the political party. Upon issuance of show cause notice, the MLAs filed a reply stating that they did not intend to withdraw support to BJP but had withdrawn support only from the government headed by Shri Yediyurappa and that they would support any BJP government headed by a clean and efficient person. They asserted that their conduct did not fall within the scope of paragraph 21A of the 10th schedule. The Speaker, however, disqualified the MLAs under paragraph 21A of the 10th schedule. The Speaker's decision was challenged before the divisional bench of Karnataka High Court. The division bench, comprising of Honorable Chief Justice and Justice N. Kumar, gave differing judgments. The Honorable Chief Justice rejected all the contentions of the MLAs and dismissed the writ petitions, while Justice N. Kumar, in his separate judgment, differed with the views of the Honorable Chief Justice in regards to interpretation of paragraph 21A of the 10th schedule and set aside the Speaker's order. The matter was then referred to a third judge, who in turn concurred with the judgment of the Honorable Chief Justice. Thus, by a majority, it was held that Speaker had rightly disqualified BJP MLAs. The order of the Speaker and the judgment of the High Court was challenged before the Honorable Supreme Court. In its judgment, the Honorable Supreme Court extensively referred to with approval the observations made by the dissenting judge of the Karnataka High Court, Justice N. Kumar. I am in complete agreement with this view and am bound by it. I reproduce the said paragraph which are relevant for the present purpose. Justice N. Kumar, who along with the Chief Justice heard writ petitions filed by the appellant herein, in his separate judgment, differed the views expressed by the Chief Justice in regards to the interpretation of paragraph 21A of the 10th schedule of the Constitution. The learned judge went on to further hold that when a member of a house expressed his no confidence in the leader of a legislative party, and if he happened to be the Chief Minister who is heading the Council of Ministers and had written to the Governor in that regard, such act by itself would not amount to an act of floor crossing. Similarly, if the Governor, after taking note of the expression of no confidence, was satisfied that the Chief Minister had lost majority support in the House, he could call upon the Chief Minister to prove his majority on the floor of the House. It was further observed that if the Chief Minister, on such request, failed to establish that he enjoyed the support of the majority of the members, the ministry would fall. But such an act of the member of the House would not constitute defection under 10th schedule. By such an act, the political party which had formed the government would not lose its right to form a government again. On the other hand, what is disturbed by such an act is the government of the political party with a particular leader in whom the members of the House belonging to the same political party have no confidence. But this would not mean that the member of the political party to which the Chief Minister belonged had given up his membership to the political party. Having dealt with the various decisions referred to hereinabove, the learned judge came to the conclusion that it was clear that an act of no confidence in the leader of the legislative party does not amount to his voluntarily giving up membership of the political party. Similarly, his act of expressing no confidence in the government formed by the party with a particular leader as the Chief Minister would not also amount to a voluntary act of giving up the membership of that political party. The learned judge further observed that deserting the leader and deserting the government is not synonymous with deserting the party. If a member resigned from the ministry, it would not amount to defection. What constitutes defection under paragraph 21A of the 10th schedule is deserting the party. The learned judge observed that dissent is not defection, and the 10th schedule, while recognizing dissent, prohibits defection. In this background, on an appreciation of facts on record, I find that the present petition do not attract or justify actions under the 10th schedule. In my view, the petitioner cannot and should not use the provisions of 10th schedule as a weapon to silence or browbeat the members or to crush opposition. That would be a complete abuse of the process of law and would run counter to the constitutional intent behind the 10th schedule. It also underlines the instance of the Election Commission of India to bring about changes in the party constitution to make it more democratic by providing party cadre a platform to express themselves and give them a voice in the party's decision making. It may be that some members go overboard and make some statements or do some acts which may be in breach of party discipline. It would be for the political party to deal with them appropriately and not for the 10th schedule. Looking at the degree or gravity of the indiscipline, the concerned members may be censured, admonished, or reprimanded or given a more extreme punishment such as suspension or expulsion from the party, as may be warranted by the party's rules. Even the most extreme punishment of expulsion from the party would not have the effect of these members losing their seat in the House. The members would remain as unattached members in the House, continuing to represent their constituencies, and they would still continue to be members of the political party for the purpose of 10th schedule. The 10th schedule is not intended to be used as a device for imposing inter-party discipline, much less for administering the party. No party leadership can use the provisions of 10th schedule as a deterrent to stifle the collective dissent of large number of members by threatening them with disqualification under the 10th schedule. In a given case, when a tussle for leadership arises between leaders in a political party, the elected members, as indeed the common party workers, usually cannot remain mute onlookers. They are compelled to choose sides. Whatever else may be the consequences of their action or inaction, the parties cannot expect that the Speaker's office be used to eradicate opposition or quell dissent in party ranks by employing the mechanism of the 10th schedule. 10th schedule can only enter the arena if members voluntarily give up membership of the party. As things stand, the Speaker has no role to play in the game of political tussle between warring party leaders. The Speaker's action of imposing penal consequences is prompted by the letter of the law or spirit behind the 10th schedule, which, in my considered view, is to preserve the democratic foundations of legislatures or the parliament. The Speaker must keep in mind this objective underlying the 10th schedule and see if the indiscipline falls within the provisions of paragraph 2(1)(a) of the 10th schedule. The Speaker must guard against the power under the 10th schedule from being invoked with ulterior motives for party gains. Thus, for the reasons stated above, respondents cannot be held to be disqualified on any of the grounds recorded in paragraph 76 C to H, as they do not amount to voluntarily giving up membership of the political party. Consequently, the disqualification petition number 1, 3 and 4 of 2023 are liable to be dismissed. In view of my conclusions and findings recorded here and above, petition number 1, 3 and 4 of 2023 are hereby dismissed. Shall now deal with the second group of petitions, being petition number 2 and 5 filed by the Ajit Pawar factions have been grouped as group 2. Really pronouncing the order for those petitions filed by the Ajit Pawar faction against the members belonging to the Sharad Pawar faction. The preliminary issue has already been decided, which is similar in both the groups, and I have already ruled on that and read out the relevant portions of the order which deal with that issue. Now, with regards to have respondents incurred disqualification in terms of paragraph 2(1)(a) of the 10th schedule of the Constitution on account of their acts, omissions and or conduct. So this is the respondents as in the Sharad Pawar faction MLAs, whether through their acts and conducts do they qualify for disqualification under 2(1)(a). Petitioner has contended that the respondents are liable to be disqualified on the following grounds. A. Tendered affidavits in support of Shri Sharad Pawar without seeking permission of party president Shri Ajit Pawar. Respondents, by making statements against the decision of the party to join the government, has committed anti-party activities and have thus voluntarily given up the membership of the party. In my considered opinion, irrespective of my decision that the Ajit Pawar faction was the real NCP political party when the rival factions emerged, none of the averments, contentions or pleadings raised by the petitioner in this group of petition shall fall within the ambit of paragraph 2(1)(a) of the 10th schedule of the Constitution. The object underlying the provisions in the 10th schedule was to curb the evil of political defections motivated by various considerations which endanger the foundations of our democracy. What is to be noted is that the provisions of the amendment are intended only for the purpose of prohibiting and punishing defection, and that too with the objective of preserving the foundation of democracy. The rest of them are, my observations are same with regards to the distinction between dissent and defection. I have again quoted the Justice N. Kumar's observations and the Supreme Court's observation with regards to the issue with regards to dissent and defection. We've dealt with that in the previous order as well. So I'll read out only the operative portion of this. Thus, for the reasons stated herabove, respondents cannot be held to be disqualified on any of the grounds as they do not amount to voluntarily giving up membership of the political party. Consequently, the disqualification petition number 2 and 5 of 2023 are liable to be dismissed. In view of my conclusions and findings recorded herein above, petition number 2 and 5 of 2023 are hereby dismissed. You all can apply for a certified copy, and the certified copy will be provided to you.
बोला.
आपण कोण?
अरे ते सगळं सोड. खूप चांगली इन्व्हेस्टमेंट स्कीम आली आहे. आज 2000 टाक, उद्या 4 मिळतील, परवा 8, मग 16,
मग 32, मग 64.
लिंक पाठवली आहे, लवकर क्लिक कर.
मूर्ख आहेस. किती वेळा समजावलंय? UPI म्हणतं अशा फसव्या इन्व्हेस्टमेंट वाल्या स्कीम मध्ये फसू नका. आपल्या पैशांची काळजी स्वतःच घ्या. काय समजलं?
काय समजणार? तुम्हीच समजावा, आम्ही काय समजावणार.
तुम्हीही हा व्हिडिओ शेअर करून आपल्या आजूबाजूच्या भोलाला वाचवा.
An economy is very strong, robust, and also substantial, which then opens up opportunity for countries, including particularly partners like Qatar, to become our strategic partners through the investment in that development and growth journey, but do it in a manner that is, of course, beneficial to both the partners. So not looking at pure play investments purely from the point of view of return on equity, but also on using investment as a vehicle actually